The Revised Penal Code of the Philippines, Article 62, effects of the attendance of mitigating or aggravating circumstances and of habitual delinquency. Mitigating or aggravating circumstances and habitual delinquency shall be taken into account for the purpose of diminishing or increasing the penalty in conformity with the following rules. 1. Aggravating circumstances, which in themselves constitute a crime, especially punishable by law, or which are included by the law in defining a crime and prescribing the penalty thereof, shall not be taken into account for the purpose of increasing the penalty. 1A. When in the commission of the crime, advantage was taken by the offender of his public position, the penalty to be imposed shall be in its maximum regardless of mitigating circumstances. The maximum penalty shall be imposed if the offense was committed by any person who belongs to an organized or syndicated crime group. An unorganized or syndicated crime group means a group of two or more persons collaborating, confederating, or mutually helping one another for purposes of gain in the commission of any crime. 2. The same rule shall apply with respect to any aggravating circumstances inherent in the crime to such a degree that it must be necessity accompany the commission thereof. 3. Aggravating or mitigating circumstances which arise from the moral attributes of the offender or from his private relations with the offended party or from any other personal cause shall only serve to aggravate or mitigate the liability of the principals, accomplices, and accessories as to whom each circumstances are attendant. 4. The circumstances which consist in the material execution of the act or in the means employed to accomplish it shall serve to aggravate or mitigate the liability of those persons only who had knowledge of them at the time of the execution of the act or their cooperation therein. 5. Habitual delinquency shall have the following effects. A. Upon a third conviction, the culprit shall be sentenced to the penalty provided by law for the last crime of which he be found guilty and the additional penalty of prison correctional in its medium and maximum periods. B. Upon a fourth conviction, the culprit shall be sentenced to the penalty provided for the last crime of which he is found guilty and to the additional penalty of prison mayor in its minimum and medium periods. And C. Upon fifth or additional conviction, the culprit shall be sentenced to the penalty provided for the last crime of which he be found guilty and to the additional penalty of prison mayor in its maximum period to reclusion temporal in its minimum period. Notwithstanding the provision of this article, the total of the two penalties to be imposed upon the offender in conformity herewith shall in no case exceed 30 years. For the purpose of this article, a person shall be deemed to be habitual delinquent if within a period of 10 years from the date of his release or last conviction of the crimes of serious or less serious physical injuries, robo, hurto, estafa, or falsification, he is found of any of said crimes a third time or oftener. Article 63. Rules for the application of indivisible penalties. In all cases in which the law prescribes a single indivisible penalty, it shall be applied by the courts regardless of any mitigating or aggravating circumstances that may have attended the commission of the deed. In all cases in which the law prescribes a penalty composed of two indivisible penalties, the following rules shall be observed in the application thereof. 1. When the commission of the deed there is present only one aggravating circumstance, the greater penalty shall be applied. 2. when there are neither mitigating nor aggravating circumstances in the commission of the deed, the lesser penalty shall be applied. 3. When the commission of the act is attended by some mitigating circumstance and there is no aggravating circumstance, the lesser penalty shall be applied. 4. When both mitigating and aggravating circumstances attended the commission of the act, the court shall reasonably allow them to offset one another in consideration of their number and importance, for the purpose of applying the penalty in accordance with the preceding rules, according to the result of such compensation. Article 64. Rules for the application of penalties, which contain 3 periods. In cases in which the penalties prescribed by law contain 3 periods, whenever it be single divisible penalty or composed of three different penalties, each one of which forms a period in accordance with the provisions of Articles 76 and 77, the courts shall observe for the application of the penalty the following rules, according to whether there are or are no mitigating or aggravating circumstances. 1. When there are neither aggravating nor mitigating circumstance, they shall impose the penalty prescribed by law in its medium period. 2. When only mitigating circumstance is present in the commission of the act, they shall impose the penalty of its minimum period. When 3. When only aggravating circumstance is present in the commission of the act, they shall impose the penalty of in its maximum period. 4. When both mitigating and aggravating circumstances are present, the court shall reasonably offset those of one class against the other according to their relative weight. 5. When there are 2 or more mitigating circumstances and no aggravating circumstances are present, the court shall impose the penalty next lower to that prescribed by law in the period that it may deem applicable, according to the number and nature of such circumstances. 6. Whatever may be the number and nature of the aggravating circumstances, the court shall not impose a greater penalty than that prescribed by law in its maximum period. 7. Within the limits of each period, the courts shall determine the extent of the penalty according to the number and nature of the aggravating and mitigating circumstances and the greater or lesser extent of the evil produced by the crime. Article 65. Rule in cases in which the penalty is not composed of 3 periods. In cases in which the penalty prescribed by law is not composed of 3 periods, the court shall apply the rules contained in the foregoing articles, dividing into 3 equal portions the time included in the penalty prescribed and forming 1 period of each of the 3 portions. Article 66. Imposition of fines. In imposing fines, the court may fix any amount within the limits established by law. In fixing the amount in each case, attention shall be given not only to the mitigating and aggravating circumstances, but more particularly to the wealth or means of the culprit. Article 67. Penalty to be imposed when not all the requisites of exemption of the fourth circumstances of Article 12 are present. When all the conditions required in circumstance number 4 of Article 12 of this code to exempt from criminal liability are not present, the penalty of arresto mayor in its maximum period to prison correctional in its minimum period shall be imposed upon the culprit if he shall have been guilty of the grave felony, and arresto mayor in its minimum and medium periods if or of less grave felony. Article 68. Penalty to be imposed upon a person under 18 years of age. When the offender is a minor under 18 years and his case is one coming under the provisions of the paragraph next to the last of Article 80 of this code, the following rules shall be observed. 1. Upon a person under 15 but over 9 years of age who is not exempted from from liability by reason of the court having declared that he acted with discernment. A discretionary penalty shall be imposed but always lower by 2 degrees, at least than that prescribed by law for the crime which he committed. 2. Upon a person over 15 and under 18 years of age, the penalty next lower than that prescribed by law shall be imposed, but always in the proper period. Article 69. Penalty to be imposed when the crime committed is not wholly excusable. A penalty lower by 1 or 2 degrees than that prescribed by law shall be imposed if the deed is not wholly excusable by reason of the lack of some of the conditions required to justify the same or to exempt from criminal liability in the several cases mentioned in Articles 11 and 12, provided that the majority of such conditions be present. The courts shall impose the penalty in the period which may be deemed proper in view of the number and nature of the conditions of exemption present or lacking. Article 70. Successive service of sentence. When the culprit has to serve 2 or more penalties, he shall serve them simultaneously if the nature of the penalties will so permit. Otherwise, the following rules shall be observed. In the imposition of the penalties, the order of their respective severity shall be followed so that they may be executed successively or as nearly as may be possible. Should a pardon have been granted as to the penalty or penalties first imposed, or should they have been served out? For the purpose of applying the provisions of the next preceding paragraph, the respective severity of the penalties shall be determined in accordance with the following scale. 1. Death. 2. Reclusion perpetua, reclusion temporal, prison mayor, prison correctional, arresto mayor, arresto menor, destierro, perpetual absolute disqualification, temporary absolute disqualification, suspension from public office, the right to vote and be voted for, and the right to follow a profession or calling, and public censure. Notwithstanding the provisions of the rule next preceding, the maximum duration of the convict's sentence shall not be more than the threefold the length of time corresponding to the most severe of the penalties imposed upon him. No other penalty to which he may be liable shall be inflicted after the sum total of those imposed equals the said maximum period. Such maximum period shall in no case exceed 40 years. In applying the provisions of this rule, the duration of perpetual penalties shall be computed as 30 years. Article 71. Graduated scales. In the cases in which the law prescribes a penalty lower or higher by 1 or more degrees than another given penalty, the rules prescribed in Article 61 shall be observed in graduating such penalty. The lower or higher penalty shall be taken from the graduated scale in which is comprised the given penalty. The courts, in applying such lower or higher penalty, shall observe the following graduated scales. Scale 1, death, reclusion perpetua, reclusion temporal, prison mayor, prison correctional, arresto mayor, destierro, arresto menor, public censure, fine. Scale 2, perpetual absolute disqualification, temporary absolute disqualification, suspension from public office, the right to vote and be voted for, and the right to follow a profession or calling. Public censure, fine. Article 72. Preference in the payment of the civil liabilities. The civil liabilities of a person found guilty of 2 or more offenses shall be satisfied by following the chronological order of the dates of the final judgment rendered against him, beginning the first in order of time. Section 3. Provisions common in the last two preceding section. Article 73. Presumption in regard to the imposition of accessory penalties. Whenever the courts shall impose a penalty which A provision of law carries with it other penalties. According to the provisions of Article 40, 41, 42, 43, 44, and 45 of this code, it must be understood that the accessory penalties are also imposed upon the convict. Article 74. Penalty higher than reclusion perpetua in certain cases. In cases in which the law prescribes a penalty higher than another given penalty without specifically designating the name of the former, if such higher penalty should be that of death, the same penalty and the accessory penalties of Article 40 shall be considered as the higher penalty. Article 75. Increasing or reducing the penalty of fine by one or more degrees. Whenever it may be necessary to increase or reduce the penalty of fine by one or more degrees, it shall be increased or reduced respectively for each degree by 1/4 of the maximum amount prescribed by law without however changing the minimum. The same rules shall be observed with regard to fines that do not consist of a fixed amount but are made proportional. Article 76. Legal period of duration of divisible penalties. The legal period of duration of divisible penalties shall be considered as divided into three parts, forming three periods: the minimum, the medium, and the maximum in the manner shown in the following table. Article 77. When the penalty is a complex one, composed of three distinct penalties. In cases in which the law prescribes a penalty composed of three distinct penalties, each one shall form a period. The lightest of them shall be the minimum, the next the medium, and the most severe the maximum period. Whenever the penalty prescribed does not have one of the forms especially provided for this code, the periods shall be distributed, applying by analogy the prescribed rules. Chapter 5, Execution and Service of Penalties, Section 1, General Provisions, Article 78, When and how a penalty is to be executed. No penalty shall be executed except by virtue of final judgment. A penalty shall not be executed in any other form than that prescribed by law, nor with any other circumstances or incidents than those expressly authorized thereby. In addition to the provisions of the law, the special regulations prescribed for the government of the institution in which the penalties are to be suffered shall be observed with regard to the character of the work to be performed, the time of its performance, and other incidents connected therewith, the relations of the convicts among themselves and other persons, the relief which they may receive, and their diet. The regulations shall make provisions for the separation of the sexes in different institutions, or at least into different departments, and also for the correction and reform of the convicts. Article 79. Suspension of the execution and service of the penalties in case of insanity. When a convict shall become insane or an imbecile after final sentence has been pronounced, the execution of said sentence shall be suspended only with regard to the personal penalty. The provisions of the second paragraph of circumstance number 1 of Article 12 being observed in the corresponding cases. If at any time the convict shall recover his reason, his sentence shall be executed unless the penalty shall have been prescribed in accordance with the provisions of this code. The respective provisions of this section shall also be observed if the insanity or imbecility occurs while the convict is serving his sentence. Section 2. Execution of Principal Penalties. Article 86. Reclusion perpetua, reclusion temporal, prison mayor, prison correctional, and arresto mayor. The penalties of reclusion perpetua, reclusion temporal, prison mayor, prison, correctional, and arresto mayor shall be executed and served in the places and penal establishment provided by administrative code in force or which may be provided by law in the future. Article 87, Gistero. Any person sentenced to Gistero shall not be permitted to enter the place or places designated in the sentence, nor within the radius therein specified, which shall not be more than 250 and not less than 25 kilometers from the place designated. Article 88, Arresto Menor. The penalty of arresto menor shall be served in the municipal jail or in the house of the defendant himself under the surveillance of an officer of the law, when the court so provides in each decision, taking into consideration the health of the offender and other reasons which may seem satisfactory to it.